This is a presentation of Employment Law and COVID-19, Community Legal Clinic of York Region. This presentation contains general legal information about employment law in light of the COVID-19 pandemic. It is not intended to be used as legal advice for a specific legal problem. If you are facing issues in regard to your employment, please contact the Community Legal Clinic of your region. In this video, we will be discussing employment rights in the context of COVID-19. In particular, we address leaves of absence under the Employment Standard Act 2000 ESA, rights upon layoff, work reduction under Employment Standard Act and Employment Contract Common Law, the right to refuse unsafe work, Occupational Health and Safety Act, insurance for losses as a result of contracting COVID-19 at work, Workplace Safety and Insurance Board, discrimination and accommodation in the workplace, the Human Rights Code. Leaves of absence under the Employment Standard Act 2000 ESA. The Employment Standard Act ESA set out the minimum or basic rights and protections for employees. Any employment contract in Ontario must have the same or higher level of rights and protection as the ESA. Currently, most employees in Ontario are protected by the ESA. The ESA has to be considered in connection with other legislation such as the Ontario Human Rights Code, the Occupational Health and Safety Act, and the Workplace Safety and Insurance Act when we consider the current implication as a result of COVID-19. We will start this video by reviewing the job protected leaves under the Employment Standard Act that employees may need to access due to COVID-19. Sick leave, family responsibility leave, and bereavement leave. These following three leaves are unpaid and provide employees with a given number of days off of work each calendar year for the specific purposes. The allotted days can be taken together or separately. Sick leave. This leave provides 3 unpaid days when the employee suffers from a personal illness, injury, or other medical emergency. Family responsibility leave. This leave provides 3 unpaid days for needs related to the illness, injury, medical emergency, or urgent matter of a family member. Bereavement leave. Employees can take 2 unpaid days to deal with funerals and estate matters related to a death in their family. Emergency leave. Declare emergencies and infectious disease emergencies. On March 17, 2020, the Government of Ontario declared a state of emergency under Section 7 of the Emergency Management and Civil Protection Act. The ESA was subsequently amended on March 19, 2020 to expand job protections in the context of the declared infectious disease emergency. This action triggered the Employment Standard Act emergency leave, declare emergency and infectious disease emergencies. This infectious disease leave is retroactive to January 25, 2020 and will continue as long as the state of emergency is in place. This leave allows for unpaid and job-protected emergency leaves for employees unable to perform their duties due to a declaration of emergency when A. The employee is under an order for quarantine or self-isolation or is under medical supervision or treatment related to COVID-19. B. The employee has to provide care or assistance to a family member or to a relative. This could include where school and or daycare closures have imposed obligation on the employee to take care of their children. C. The employee's workplace has been ordered to close as a result of the state of emergency. and the employer has not asked the employee to work from home. D. The employee is self-isolating as long as the employee is acting on information or direction provided by a public health authority. E. The employer requires the employee not to work because the employer is concerned that the employee may expose others in the workplace to COVID-19. And F. The employee has been unable to return to Ontario as a result of travel restrictions imposed due to COVID-19. Notice and evidence of entitlement. Notice, employees who need to take this leave are expected to let their employer know before taking the leave. If it is not possible to notify the employer beforehand, they should do so as soon as possible after starting the leave. Evidence. An employer can require an employee to provide reasonable evidence under the circumstances that the employee is entitled to the leave. However, in the case of infectious diseases, the employer cannot ask the employee to produce a doctor's note. Additional rights relating to leaves. No reprisal. An employer cannot reprise against, meaning to punish or threaten to punish any employee for thinking of or taking a leave under the ESA, including the leaves discussed in this video. Other entitlements. During these leaves, employees are entitled to continue to participate in the regular benefit, health plan, and pension plans. Closing considerations. Aside from the stated circumstances where the employee is eligible to take a job-protected leave, employers are entitled to lawfully require employees to work. This requirement is subject to rights that an employee may have under other legislations. We will be discussing those rights later in this video. Rights upon layoff and reduction in working hours. Due to the current state of emergency related to COVID-19, many employees had been laid off or had their hours of work reduced. For non-unionized workers, rights regarding layoff can depend on 1. The ESA, 2. Your contract of employment, and or common law rights. Layoffs under the ESA. The ESA allows for temporary layoffs that are not considered to be terminations. For the purposes of the ESA, a week of layoff is a week in which the employee earns less than half of what they would usually earn or earns on average in a week. Under the ESA, temporary layoffs can last up to 13 weeks in a 20-week period. They can be extended to 35 weeks in a 52-week period if the employer meets certain additional conditions, including providing substantial payment to the employee and continuing benefits, dental, medical, drugs. At the end of the 13 weeks or 35 weeks of layoff, you may be considered terminated and entitled to termination pay and, in certain circumstances, severance pay. While an in-depth discussion on termination pay and severance pay entitlement is outside the scope of this video, please call our clinic so we can address any questions or concerns you may have. Temporary layoffs, reduction in pay and or work, contract of employment, common law. In addition to the rights and protection established by the ESA, an employment contract may also determine rights, obligations, and conditions of employment. These contractual rights and obligations may be written or verbal. Additionally, rights, obligations, and conditions of employment may be determined by principles that have been established by courts through judge-made law known as the common law. Under ordinary circumstances, in order for the temporary layoff to be allowed under the common law, the employment contract must explicitly authorize it. If your employment contract doesn't authorize temporary layoffs, your employer may ask you to sign an authorization for the layoff or a new employment contract. It is recommended that you seek legal advice before you agree to this. If the employer lays you off and your employment contract doesn't authorize it, this may have legal consequences. An employee in this situation may be able to claim that he or she has been contractually dismissed. Similarly, in general, you may have the right to claim that you have been contractually dismissed if your hours have been significantly reduced. However, it is important to note that given the unprecedented nature of COVID-19, it is possible that courts will not follow general principles and instead provide greater flexibility to employers. In employment law, contracted dismissal occurs when an employer fails to comply with the employment contract in a significant way and or has made substantial changes to the terms of employment without the employee's consent. These changes may include reduction in salary, hours, employee's work location, hours of work, authority, or position. However, as previously mentioned, the current environment may vary what is considered to be a contracted dismissal. The remedy in the event of a contracted dismissal is that the employee may treat the employment as having come to an end, and they can seek notice entitlements as if they were laid off or dismissed. Entitlements upon layoff or contracted dismissal. Generally, the employer can lay off or contractually dismiss an employee as long as the employer gives the employee enough advance notice or pay instead of notice. Notice is not required when the termination or dismissal is for cause, willful misconduct, disobedience, or willful neglect of duty that is not trivial. Depending on the provisions that are stipulated in the employment contract, the employee may be entitled to reasonable notice at common law. Unlike termination pay and severance pay under the ESA, reasonable notice at common law is determined by the court through an analysis of a variety of factors related to your employment. The employee may alternatively be entitled only to the minimum standard of notice of termination or pay in lieu of notice, and in certain circumstances, severance pay under the ESA. The contract may alternatively provide for a specified amount of pay instead of notice. We may be able to provide more information and advise you about your specific situation in this regard. If you have been laid off, whether temporarily or permanently, you may be also be eligible for Community Emergency Response Benefit, CERB, and or Employment Insurance Benefit. Please see our video on CERB and Employment Insurance Benefit here. In this section, we will be discussing the Ontario Occupational Health and Safety Act, OHSA. In normal circumstances, under the OHSA, all workers have the right to refuse unsafe work if they think it is dangerous. This right of refusal may apply to work environments where you believe you may be unacceptably exposed to COVID-19 based on facts specific to your workplace. You cannot simply refuse work because of the general fear that you will become ill by going to work, or if the work is inherently dangerous, for example, working in healthcare. If you wish to refuse work due to concerns of exposure to COVID-19, you should start by 1. Explaining to your supervisor, employer, that the work is unsafe and you are refusing to do it. If there is a health and safety representative, you should tell them as well. 2. Once you have refused the unsafe work, your employer has the obligation to investigate the issue as soon as possible. You have the right to be present during the investigation, or you can wait in a safe part of the workplace if one exists. 3 is if after the investigation the employer determines that there is a health and safety issue, they are required to discuss potential solutions with you. For example, this solution could include allowing you to work from home or providing you with protective equipment. 4. If after the investigation your employer claims there are no issues but you are still concerned, then you should contact the Ministry of Labor Health and Safety Contact Center. Telephone 1-877-202-0008 and request a formal inspection of the workplace. 5. At this moment, the Ministry of Labor may be experiencing a high call volume, and so you may have to leave a message and someone will call you back. But once you formally requested a workplace inspection, an inspector will come to your workplace and gather evidence to determine if the work is unsafe. 6. You have the right to be present for the inspector's visit if you wish. 7. The inspector has the authority to order the employer to make adjustments, including shutting down the workplace. The employer cannot reprimand or punish you for exercising your rights to refuse unsafe work. But if your employer attempts to punish you for raising concerns about COVID-19, then you can make an application to the Ontario Labour Relations Board. You can call our clinic and we can provide you with further information on your specific scenario. We are now moving to our next section in which we will be discussing the Workplace Safety and Insurance Board, WSIB benefits. Workplace Safety and Insurance Board, WSIB benefits. Workers who contract COVID-19 in the workplace can make a claim for benefits with the Workplace Safety and Insurance Board, WSIB. WSIB provides benefits and payment for injuries and diseases related to the work that you do. If you believe you may have contracted COVID-19 at work, you should tell your employer and get medical treatment right away. If you are receiving treatment from a medical professional, you should tell that person treating you to send a health professional's report, Form 8, to the WSIB. To apply for WSIB benefits, you should complete and sign the Workers' Report of Injury Disease, Form 6. You can get this form on the WSIB website, or you can phone the WSIB toll-free at 1-800-387-0750 or call 416-344-1000. If you are not sure whether your employer is covered by WSIB, you can find out by calling the WSIB at the above phone number. At the Community Legal Clinic of York Region, we can provide you with more information regarding WSIB. Finally, in this last section, we will be discussing the Human Rights Code, the Code. In Ontario, employees have the right to equal treatment in employment with respect to the characteristics that are listed in the Human Rights Code, the Code. These are called prohibited grounds of discrimination: ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, disability. Employees, therefore, have the right to be free from discrimination and harassment in the workplace on the basis of the prohibited grounds. In determining whether treatment violated the code, it is not necessary to prove that the intention was to discriminate. What is important is whether the effect of the rule or treatment is discriminatory or creates a distinction on the basis of a prohibited ground. An important aspect of human rights protection under the Code is that it provides employees with the right to accommodation. Where a worker has particular needs related to one of the Code's grounds, employers are required to accommodate the worker's needs as long as it wouldn't cause them undue hardship. Undue hardship may be as a result of excessive costs or creating a health and safety risk in the workplace. However, it is not enough for an employer to show that there is some cost to accommodating the employee, as undue hardship is considered to be a high threshold. It should also be noted that accommodation doesn't go so far as to relieve an employee from the essential duties of their job. It is important for employees to always express these needs to their employer and to try to work with their employer to find an appropriate accommodation. We will be discussing the grounds of disability, place of origin, ethnic origin and race, and family status as they relate to COVID-19 in the workplace. Disability and COVID-19. Disability covers many conditions of a variety of levels of severity. A disability may have been present from birth, caused by an accident, or developed over time. Some are visible and some not. The Code protects people with past, present, and even perceived disabilities. It doesn't cover extremely short-term illnesses with only temporary effects, such as the common cold or the flu. The Code provides protections for individuals who have or are perceived to have a disability. Due to the novelty of COVID-19, there has not been a determination from the Human Rights Tribunal of Ontario as to its status as a disability. However, on March 13, 2020, the Ontario Human Rights Commission released a policy statement in which it provided its opinion that COVID-19 is a disability. While the opinions of the Commission are not binding, they are persuasive. We believe that until the issue is better resolved, employers should treat it as a disability, and workers with COVID-19 should have the same rights as anyone with a disability. As such, the employer will be required to provide the worker with reasonable accommodation, which may include a leave of absence. Workers may also have an existing disability, which elevates the risk of serious illness related to working where exposure to COVID-19 may occur. Such a situation will require an accommodation. For example, working from home, using protective equipment, working shifts staggered from coworkers, being placed on a leave of absence, etc. Where a worker is requesting a workplace accommodation on the basis of a disability related to COVID-19, employers may require a medical note. The medical note should set out the medical restriction relating to the disability. In light of the current social distancing rules and strain of healthcare resources, employers must act reasonably and understand that it may not be possible to obtain a medical note immediately. Ethnic origin, place of origin, and race. If an employee is treated differently or experiences harassment based on their ethnic origin, place of origin, and race, this is a violation of the code. COVID-19 risk is associated with certain behaviors, such as travel or contact with those who have COVID-19, but not with one's place of origin or race. It is therefore contrary to the code to create a distinction in treatment based on ethnic origin, place of origin, or race in a workplace policy or practice regarding the prevention of COVID-19. Family status and COVID-19. Workers are also protected from discrimination because of family status, which means being in a parent-child relationship. Someone who has substantial care obligations for either their child or their parent may be entitled to accommodation in the workplace. For example, if a worker lives with a parent who has a compromised immune system, they may not be able to work outside their home or work at all. They should first talk to their employer and discuss what accommodation options there may be. There may be accommodation to make their work safer, or if not, the worker may be unable to work due to the unalterable risk of the job. As discussed previously, currently the ESA emergency leave also provides time off work for parents who have child care obligations arising from school daycare closures as a result of the state of emergency. Enforcement. If you believe that your human rights have been violated, you may want to enforce your right by making a claim with the Human Rights Tribunal of Ontario or by suing the employer in court. It is advisable to seek legal advice before pursuing one or the other avenue. Conclusion. If you have any specific questions related to your employment and you live in York Region, Ontario, please contact our clinic at 905 508 5018 or check our website www.clcyr.on.ca. We provide free legal services for low-income residents of York Region, Ontario.